Okay.
And just a bit of background here. If you are on okay, I don't have to read the source. If you're on an aircraft, and you get some people that travel to Israel, especially obviously observant people like us, they want to have a minyan on a plane. And sometimes they 10 guys stand and they block the air hostesses, the flight attendants' path to do their work, and it actually causes a chilul Hashem. So some people say, rather daven in your seat. Because the one airline, someone said they peed off some of the flight attendants, some of these guys davening. They blocked the whole back part of the aircraft where the wing is, where the tail is, and they weren't very impressed. I mean, it literally blocked it. There were 15 oaks davening in a minyan there, instead of davening in their seats and causing it, because we mustn't think that we're so frum, you know. At the end of the day, we've got to be careful. You be sanua and just do the right thing and think. We need to use our brains. I'm talking to myself as well. You need to think. So that's just the introduction. Let me continue tomorrow. I don't want to take your time. So you need to just think. I know we're observant. We need to do the mitzvot. We need to daven. We need to learn. But you need to think about other people as well and be considerate and not cause ill feeling towards Judaism or Jews.
That's interesting. So it's a very good point, Yura. I want to ask you something. So if there's a minyan that's going on there and they call you to do a minyan at the back, then what you're supposed to do? Say no, then I guess.
Possibly speak to a raw, but it's not a good thing. Especially if it's like British Airways or non-Jewish airline. It's not El Al. El Al, it's expected, but it's not encouraged on El Al either.
I understand that, but let's say they've got none.
If we don't have an answer, can I ask you a favor? I'm not being funny. We're pressed for time, but what I'm saying
is... All right, let's move forward.
No. I'm saying this is actually an important point. Maybe you want to ask Edwin or one of the guys, or Rabbi Albach or whatever, because it's a great question. But we're not going to work it out here. So
I'm saying this is a question. If anybody asks, if there's 9 people standing at the back and they come call you to do a minyan, either you got to piss them off and not do a minyan and have a problem with Hashem, or you can do a chilul Hashem because you're standing at the back blocking everything. It's a very tricky one. I'm just saying that's a
ask him, you need an answer from Rabbi Albach is a measured person. He's a good guy to ask.
If they've got a minyan, then you can just stay in your seat. You got a choice. You don't have that predicament.
Maybe you shouldn't join the minyan.
Okay, I don't know.
Okay.
Guys, it's not an answer yet. I'm just giving the question.
Yes, we're discussing it here. No, it could be. Maybe you're right.
All right, look, the bottom line of it is if 9 people have blocked the pathway, the 10th isn't going to add anything, and you can be part of a minyan.
Yeah.
All right, let's go. Just pure logic.
Probably, yeah.
Okay, so look, the Gemara records an incident. Guys, there was a certain man who cut down his fellow's palm tree, and the damager came before the exile ark for judgment. So let me explain to you what an exile ark was. You had judges within Eretz Israel, and they could paskin knas. Knas is a penalty. So remember, all your penalty payments couldn't be implemented outside of Eretz Israel, even though it was part of the law. You know, you'd have to pay your nezek shalom, your actual damage, but all knasim could only be done within Eretz Israel. So as far as that's concerned, you had judges within Eretz Israel and judges within Babylon and surrounds. So judges within Babylon and surrounds were known as exile arks, which comes from the word exile, obviously. Now, basically, so this guy cut down his fellow's palm tree, and he came to the local court in Babylon, wherever it was in Galus, and the damager came before him as well as the other party, and the exile ark said to him, listen, I myself saw that the tree was cut down. It was one of 3 palm trees that stood in one place, and together they were worth 100 zuz. So therefore, go and give the owner 33 1/3 of zuz. Does that make sense, guys? It does, doesn't it? From what we know.
Where did you get that? Where did the calculation come from?
So what happened was it's part of the Gemara. It is part of the Gemara on our side. I tell you what, it's on the 58th daf in B3. Okay, so it's just citing an incident of where it came from in a certain brisa. So let's just cover ground. Bottom line, guy cuts down his fellow's palm tree. It happens to be that the judge actually saw the incident and said, listen, this wasn't an independent tree. It was part of a group of 3 palm trees. And since that was the case, and the 3 trees together were 100 zuz, I'm sure he asked them what it was worth, and he said, I paid 100 zuz for it. I'm sure the damaged party had to give it in evidence. He said, look, you cut down 1/3, so that's 33 1/3 zuz that you have to give. Now, the damager was really upset by this, because he said, look, why do I have to be involved with the XLR post-Persian law? Okay, guys, I think Arthur, your mic is on. Who's on in the background? That's did Arthur put it on mute? Perfect. So the person that the damager was very distressed by this, because he said, look, why do I have to be involved with this XLR imposed Persian law? Because Persian law says, look, these are the amount of trees together. This is what you damaged, and therefore you're paying 1/3 of that. So he wasn't very happy. So he went to Rav Nachman for judgment, and Rav Nachman said to him, this tree is a valuation, right? But not in relation to the 2 other trees, making 3 trees in total, in relation to 60 trees. Now, guys, where do we get 60 trees from?
The 160th story.
Correct, from Chizkiah. That's exactly it. Is that even your 3 opinions, it says that basically that the damager pays how much of the value of 60 trees with their land would be reduced in the event that 1 tree was cut down. So he said, listen, I'm not paying 1 1/3 here. I'm paying 1 1/60. That's Torah law. I'm not going to be imposed by Persian law. And Rav Nachman ruled in this man's favor. Okay. Now, Rava disagreed with Rav Nachman. Why? Rava said to him, look, they said that the appraisal is based on the ratio of 1 to 60, where one's property causes damage. But would they say that also applies when the person himself causes the damage? Meaning that this method of appraisal, which benefits the damager, is used only when it was his property that caused the damage, and not in a case where he did the damage directly as a person. Does that make sense?
Yeah.
And I mean, we've learned this before. We've learned this before. I mean, take a classic case of an animal. If an animal butts into you, you only pay for actual damage. But if a person hits another person, you pay for pain, you're paying for healing, medical bills, humiliation, recovery, earnings lost, etc. So we often see that the property damaging is more lenient than a human being damaging a human being. But we haven't seen what happens when a human being damages property. Is it as tough as when a human being does a bad thing to another human? Or is it as lenient as when a human being, when an animal does damage to a property? Does that make sense? So the only point of stringency we've seen up until now is human on human. Does that make sense? Not human on property. Okay, so this is the argument between Rav and Rav Nachman. Now, Rav's position is challenged. Why? Now, who generally challenges Rav's opinion? It's a buyer, because they were obviously at a contemporary era. What's your reason for asserting that we don't use this method of appraisal? A buyer said to Rav, when the person himself caused the damage. It's based on that which was taught in the following brisa. If one destroys his fellow's vineyard when its fruit is budding, we view how much the vineyard was worth before the damage and how much it was worth afterwards, and the damager pays the difference. Now, the brisa doesn't say that the devastated area is assessed in relation to a vineyard 60 times larger. The mission basically supports your view, Rava. So it seems so far that the buyer is agreeing with Rava, right? Because you say, listen, I found a brisa that agrees with you, saying you're only looking at that particular devastated area and not in a vineyard 60 times larger. And he's talking about a brisa where it discusses his fellow's vineyard when the fruit is budding. And when a person destroys his fellow's vineyard. So the emissions support your view, Rabba, that one who damages with his own hands must pay the full independent value of the damaged property. So far, it seems like a buyer is agreeing with Rabba. But we know that that doesn't generally happen. So what does he say? He said, but it's not a valid proof. Why? Because in connection with damage caused by one's animal as well, was not another brisa stated in the same manner. In other words, it makes the same omission. Because, so what's the omission, Gavin? What omission are we talking about?
I don't recall the section so well, but my logic would be quite. So I just wanted to make. Sorry, I don't recall it 100%. But the comment I want to make is that if it's very hard to control your animals, but you can control yourself, and that's why with yourself, it should be direct damage. That's it. I mean, you should pay the full amount of the damage because you can control yourself. Animals are much more difficult.
Correct.
And if they're doing other. So that's the logic. Sorry, this part I don't recall. You'll have to answer it for me.
Okay, so basically the greater context at hand is a buyer saying to Rabba, yes, I agree with you, that what you're saying is correct, that if a person does damage, we obviously look at it in context of just the area in which he damaged and not in the greater context to lower his damages. But it's not a proof to say that if somebody damages by his own hands, that's the reason he must pay the full independent value of the damaged property. Why? Because I've just found another brisa for you that says in connection with damage caused by one's animal as well, was not another brisa stated in the same manner. It makes the omission. In other words, both brises have made their omission and stating that you only take that plot of land. It doesn't say that you take other plots of land. It says you assess that value, the value of what was damaged, implying nothing else. So he was saying, listen, you want to say it's because a person did damage and therefore they're more responsible. And I say, rather, yes, you're right that the brisa says in that one that you're talking about that a person does pay for just that particular area. But what I'm saying is it says it as well when an animal damages, it also makes you pay just in that area. So the same omission occurs with both human and animals. So therefore, it's not a proof that because somebody used his own hands to damage and not his property, that that's the reason why such a thing exists. That's the buyer's argument to Rabba. Okay? Because it taught in another brisa, if one's animal severed a young tree that belonged to another. Rav Yossi reports that those who promulgated decrees in Jerusalem say, for a tree in its first year, he pays 2 manos of silver. And for a tree in its second year, he pays 4 manos of silver. So what a buyer is saying to Rav is, you coming to think that maybe it's an issue dealing with a person versus an animal damaging in a level of responsibility. I'm telling you that the damage is in relation to the level of development that a tree has reached. In other words, I'm bringing a brisa that if you are irresponsible and your animal damages a tree that has not fully developed, that you're going to be paying penalties here. And one of those penalties is you're paying 2 manos of silver if a tree is in its first year, if your animal does damage, and 4 manos of silver if it's in its second year. Okay? Now,
Damon, can I just stop? Damon, can I stop you 1 second? Sorry, because I don't remember it. I don't understand why the animal has to pay like the first year, second year, third year. I presume if those trees are sitting inside your neighbor's property and that animal went into your neighbor's property, surely it's 1/60th. The same rule should apply. Where are those trees sitting then?
No, it's not applying, and this is exactly a buyer's point to Rabba, is that, look, you can't even prune a tree before the first 3 years. We know that. We know that people, that upshearing, they only get their hair cut in the 3rd year. There's a tradition that you don't prune a tree before its 3rd year anyway. So that's why it's talking about a tree of 1 and 2 years. So if you see, once a tree is kind of damaged, but it's developed roots and a system of internal irrigation and connection with the soil, it's got a chance of perhaps rejuvenating itself in the spring, but not even if it haven't developed that root infrastructure yet. So the thing of that is there's an extra penalty involved. So Bava is just making this point that if your person damages as well as an animal, it's no proof that you only take the land in context of that microcosm of damage and not with a ratio of 60. And it has nothing to do with the person being more responsible, because I've just proved it with another brisa that an animal is just, the owner of the animal is just as responsible for trees that are budding. And I'll prove to you what I'm saying. Because let's just look at the brisa that Abaye brought to Rav at first. It says, if one destroys his fellow's vineyard when its fruit is budding, we view how much the vineyard was worth before the damage and how much it was worth afterwards, and the damager pays the difference. So now we're talking about budding fruit. Is budding fruit fully developed fruit, yes or no?
No.
No. And now we're talking about, so that's when a person destroys his fellow's vineyard. Now we're talking about a different case. So the second brisa that Abaye is bringing to Rav, if one's animal severed a young tree that belonged to another. So now what we're saying is it seems to be that the issue at hand is not a person versus an animal with regards to his responsibility, but mainly what level of development has the produce grown to. Does that make sense? In other words, if you pick up prematurely or if you damage it prematurely, it's not seen in context of a lower fee. That's the issue that seems to be at play with the Abaye and Rav. Yeah, ask.
Damon?
Yeah.
And how does one know if that tree will even fully develop? So I think this is the question.
That's a good question.
How can they predict in the future? Maybe it won't even go past the budding stage. I mean, the fruit.
So that's a good question. So that's where the sages disagree with Rav Yossi Haglili. We're going to get to it now. So what we're saying is when you say that there's a penalty of 2 manos of silver for a tree in its first year, or 4 manos of silver in a tree in its second year, that penalty could not be issued out of Eretz Yisrael. Why? Because you can't deal with penalties out of Eretz Yisrael. Does that make sense? So those are only trees within Eretz Yisrael. There's no knas, there's no penalty out of Eretz Yisrael. The Rabbonim there could only make restitution. They couldn't enforce penalties. Now, those penalties, by the way, are minimums. In other words, the damager must pay the tree's value as appraised in the normal manner, but not less than 2 manos for a tree in its first year, 4 manos in its second year. In other words, if the tree's value exceeded that, you'd pay the exceeded amount. But you couldn't pay less than that. In other words, you can't turn around, let your animal damage that tree and say, well, it wasn't worth anything, it wasn't developed. You can't use that as an excuse for paying less. That's the issue at hand, Kevin. It's not that, as Kevin said, you necessarily pay more. But why should you pay less? In other words, the argument here is why should, according to the way Rav Yossi reports it, is why should you pay less and get off the hook because of it happens to be a young tree? You killed it in the prime of potential. So it's not that, Kevin, you necessarily. It's not necessarily an argument of saying, well, we don't know what it could have been worth. What you're also saying is, well, why should you use that as a leniency for paying less? Because we don't know what it could be worth. The person loses out either way. In other words, so that's the issue at hand. And by the way, the rabbis agree with Kevin, and I'll show you why. The brisa continues, if it ate newly sprouted grain, Rav Yossi Haglili says, we judge the loss by what remains in that field. So what does Rav Yossi Haglili says is that we have to wait until the rest of the field is ready to be harvested and note how much it is worth at the time of harvesting. That's according to Rashi. So we use that value as our guide. So in other words, we reckon the amount the devastated area would have been worth at harvest time had it been allowed to grow. And that's the amount that the damager must pay, although the damage occurred when the grain was unwrapped. So we can't make the payment due at that point. We need to see how it goes. We need to assess and see, was it a good year? Was it productive? Was it destroyed by hail? Did it grow to fruition? And at that point, make the payment rendered. So it's a disadvantage to the damaged part because he has to wait till getting payment in terms of at harvest season what the rest of the field's qualitative potential was actualized. But in a way, it also affects the damager because now he's paying more. Now, the sages actually, Kevin agrees with the sages because the sages don't agree with Rav Yossi HaGlili because they say we view how much the land was worth before the damage occurred and how much it's worth afterwards, and the damager pays the difference. What does that mean? So according to the sages, we don't assess the potential value of damaged grain, but only what it was worth when it was damaged. And why did Kevin say that? Well, firstly, because we learned it before. We said if a cow was pregnant with a calf and she lost the calf, okay, or she was pregnant, you don't say what would the calf have been worth if it had been properly born and grown up, or we don't say if a calf was young and not a fetus, not a mother with a potential fetus, what it would have reached when it achieved maturity. Because we don't know, Kevin, exactly if it would have died of some syphilis or gangrene, or if it would have been kosher, or Kev, you're falling asleep. So what I'm saying is we've learned so far exactly what Kevin says. You can't pay based on potential. That potential hasn't actualized. And Rav Yossi HaGlili is turning around saying we're not basing it on potential. We're waiting until the harvest is completed to know how it actualized. It's not guesswork, Gavin. Can you see? It's not guesswork. He's saying we're not saying it could have reached this. We're looking at the field and we see how the rest of the field turned out. And what's more, so you might say that Rav Yossi HaGlili is more strict than the sages, because the sages said, look, whatever the point of development is, you pay on that basis. Okay? And Rav Yossi HaGlili says we wait to see how the rest of the field would have matured at harvest time and then make the damager pay for that produce had it reached proper maturity. Now, there is a case where Rav Yossi HaGlili is more lenient than the sages. Let me give you an example. Say that the fruit was maybe halfway there, Kevin, halfway developed. It hadn't reached maturity and it got damaged. Now, Rav Yossi HaGlili, the sages in that case would have made him pay for like half the fruit's potential, for example. Rav Yossi HaGlili would have waited until the field had matured in terms of ready to harvest. Now, say by the time of half maturity and full maturity, there was a massive hailstorm or a infestation of locusts, and now that field was worth nothing. Then Rav Yossi HaGlili said that basically the damager pays nothing because that would have been destroyed with everything. But the sages then would be more strict and say, no, at the time that the damage was done, it was half ripe, so he gets half the money. So in certain cases, depending on how the crop turned out, the sages would be more stringent or they would be more lenient. Do you understand what I'm saying? It's not that the sages are more lenient. In a case where it all went terribly wrong, Rav Yossi HaGlili would say, listen, nothing happened with the rest of the harvest. It all turned to disaster. You don't pay anything. It happened to be that at the time when it damaged, it would have ended up in nothing. So you pay nothing. So in that way, there's a stringency and a leniency. Does that make sense, guys?
Yeah.
In other words, the major thing is they wait. So now what we're saying is, a buyer is saying to Rav, look, we're not talking that a person pays more if he damaged his fellow's grain compared to an animal. It has to do with the level of development of the produce. And the fact that you only pay it maybe in shorter context has to do with that. And he's saying, secondly, who's to say that it doesn't include viewing the other land? Sometimes it's an omission. An omission doesn't mean it's not necessarily included. You can derive it from logic. Because the pasuk in chapter 22, verse 4, has certain things out of logic that you could derive even if it wasn't there. So if you remember a stringency about a shomer, a guardian, remember it said that a borrower was responsible for unavoidable accidents. And it never stated he was liable for theft or loss. Remember that. But you didn't have to state that, because if somebody, a paid custodian, is deriving benefit, he's responsible for less, but even he's liable for theft and loss. So obviously, in addition to an unavoidable accident, the borrower is responsible for theft and loss. So logic means that not everything has to be stated. So a buyer is not arguing with Rava necessarily that you don't take it in context of larger land. He's just saying that the fact that man did the damage is not proof to the fact, because we see that that omission occurred when you were talking about animals doing damage, but both of them seem to be talking about when fruit is budding, if he ate newly sprouted grain. So we're talking about if a young tree was severed. Yeah.
My humble apologies, sir.
All right, so Gavin, what it keeps saying is it keeps using the same sort of wording. When the fruit is budding, if he ate newly sprouted grain, when he severed a young tree. So it seems to be an issue, not of man doing damage, and that's why he's paying more. It's the fact that you're killing development before it even started. So why should you get off the hook as the damager? Where you're saying, it didn't develop into anything, why should I pay it all? That's the issue at hand. So buyers just using this as a proof against Rava to say that, listen, if you want to say that man by his own hand, it's only seen in a smaller context and not in the field of 60, I could say the same thing occurs when an animal does damage. You know what I'm saying? So it's not a proof that man's doing the damage is what caused it. And he's also saying, listen, we don't know if we're only saying it's appraised within that smaller area. It could be appraised within a larger area. It's just an omission, like the issue that I just brought as an example with the borrower and a paid custodian. Sometimes logic tells you that if somebody of lesser responsibility is responsible for certain things, somebody of more responsibility that's responsible for new things is also responsible for those things. And it's a given of less responsibility anyway. Does that make sense? So that's not necessarily an admission. So anyway, we know, as Kevin said, that the sages say, look, you can't look at it on potential, even if we know what it actualized, because we have to judge with damage at that point in time. We never say a calf could have been. But Rav Yossi Aglili says, yes, we do wait, because we can see in this case what could have been. With a calf that doesn't grow into a cow, it could have died of syphilis or whatever it died of. But here, you can look at the rest of the field and make a real judgment. You actually can. There's criteria in terms of objectivity.
There you are. Okay. Damon, you need to go back 1 minute because you froze and the audio disappeared.
Wireless is just not as good as fiber. The rest of us mainly on fiber. Or Israeli wireless.
Your audio, Damon, you're on mute, huh?
Yeah, you're on mute.
Okay, guys. So all I'm saying to you is we don't know if it's seen in a smaller context or a bigger context. And Rav Yossi Aglili is saying you can't know if a calf will ever reach adulthood, but you can look at a field and see if a small amount was picked in a larger field, if it all came right, what the potential was with this other bit of produce. This is, you have got a track record post facto to check. That's all he's saying. He's saying it's different with a calf. Now, we're on 59A, and we are we're going to talk about a third case. But I just want to see how much time we've got left. What's the time, guys?
4.5 minutes.
So I'll tell you what, maybe we should end off on this note. We've reached 59A.
Then
yeah.
I have a question then to ask. I've been dying. Okay. So I kind of touched on it earlier. I didn't quite get the answer I wanted because it's actually got to do with the entire this entire section that we're doing. I read it on Saturday, but I've been sick since Friday, and I think when I read it, I was dopey, and I didn't really pick it up. I battled with this whole section because I wasn't feeling well. So this is what I wanted, and I didn't quite get it then either. I can reread it, but let me just ask you anyway. I don't I understand kind of each section individually, but I don't understand when do you take, if an animal walks into a property and destroys something, when do you take, just hear me out before you answer, eh? It's going to be 2 seconds, all right. When do you take 1/60th? When do you take, so when do you take 1/60th of the land, or take half the land and you know, do the other option? And if it's 1/60th or 1/30th using that methodology, when do you take the other methodology when you say the animal destroyed the property, let's value the land, not the 1/60th. Let's value the land before, let's value the land after, but not using the 1/60th method. And when is the animal responsible directly, like we were doing now? So I don't understand why they're different. Why is it not always one? Why are there 3 different options available? That's what I don't understand.
All right, so I'll tell you with pleasure. I wasn't interrupting you at all. So what I was going to say is, the first point of question is there ever a circumstance where you work according to Persian law? In other words, you just say, listen, it's damaged what it's damaged. You've got 3 trees that are worth 100 zuz. It's 1 tree out of 3 that was damaged, 33.5, and not times the ratio of Chizkiah by 60. Is there ever a case where Torah law mimics Persian law? And we try to find out if there's a case where that leniency does not apply of timesing it by 60. It doesn't matter in principle which one of the 60s you do. If you take a base Tarkon, a base or just times it by 60, it's still a principle of timesing it by 60 to mitigate the damages. Yes, so we're saying, is there an exception? That's the first thing that we're trying to look at. The second thing of it is a buyer doesn't agree with Rava. Rava say, look, Persian law does kick in, not Persian law. I'm saying the leniency of Torah law doesn't work as a leniency, which would seem to parallel Persian law in a case where man's done the actual damage, not his animal. And a buyer is saying no. Because if you want to take that price, I can show you this same brisa, which says that if an animal does damage, you look at it almost in terms of the area that it damaged, contextually. So you can't say because man did it by his own hand, now suddenly that leniency falls away. I could say one of 2 things. This is what a buyer is saying to Rava. Either that the leniency applies both with the person and an animal, but the person himself that does the damage isn't proof of the reason. Or I could say that it's only taken in terms of a smaller context, but your reasoning, Rava, a buyer is saying, is I don't agree with it. We've yet to see if it's according to a smaller context to a larger tract of land, but your reason doesn't apply. Because when I turn around and say that it's because the human did damage as opposed to an animal, I can show you a proof that it's not necessarily the case. And the Gemara is going to unfold and say, well, is there a case where that leniency of times 60 doesn't apply? And we're going to see. Now, that's a different issue to saying, well, what stage of development do you pay for if things were damaged before it reached its prime? That's a different issue to what was damaged in context of a larger field. They're 2 separate issues. The one is a percentage of damage in terms of overall ownership in the field, and the other one is stage of development damage. They're 2 factors. They're not contradicting each other.
No, I understand. But I think you're all going to touch on some of the issues of why the 1/60th is not used and stuff like that. So
we don't know if it's